Hello everyone, and welcome to this video on Your Idea Protection Kit by KISS Patent. I'm so glad that you're able to join us today to discuss your idea and how you can protect it. So a little bit about me. I'm Dr. Devora Grazer. I'm a U.S. patent agent, which means I'm admitted to the federal U.S. patent bar, and I can prepare and file patent applications. I have 19 years of patent experience, including 4 years programming with the Human Genome Project, and I was also Vice President of Intellectual Property at a company, meaning I've been on both sides of the table. All right, this is what happens when you hang out too much with lawyers. Nothing in this presentation or in any material provided, whether verbally or in writing, constitutes legal or patent advice. So the questions we're going to answer today are as follows. Is a patent worth it for your idea? How to protect your idea with a patent, how to do a patent search, and finally, is your idea patent worthy? Even if a patent is worth it for your idea may not yet be ready for a patent. So to start off with, let's answer the question, is a patent worth it for your idea? Well, patents provide the broadest protection for your idea. Not only can patents protect the core of your idea, but they're also the best defense against copycats. And the reason for this is that only patents can block competitors from entering your space. In other words, patent protection is so broad that you can actually protect your own niche, your own space, and prevent others from coming into that space. What is patentable? Well, anything under the sun made by the hand of man. This includes software, hardware, and high-tech. Mechanical devices, chemicals, drugs, proteins are more examples. So basically, if you have something which is software, then it would fall into a patentable category. What is not patentable? Music, images, books, video. These are protected by copyright. Names, logos, and slogans. Well, these are protected by trademarks. And of course, anything that you want to keep secret, because in order to get a patent, you have to describe your idea to the public. So what do you want to patent? Well, you need to patent the heart of your business. The heart of your business is that idea or ideas or innovation without which your business would fail. Also, the heart of your business is that part of your business that if someone else copied would most damage your business. If you consider it carefully, you'll know if your idea is actually the heart of your business or not. And if it is, then you do want to patent it. But why bother with patents? Well, the main reason is to increase your idea's value, and hence to increase your startup's value, for example, if you have a company. Patents can increase the value of your idea because they take that idea and they turn it into a form of property. And for this reason, they increase your idea's value to the outside world, for example, to investors, to people who might want to purchase your company, and so forth. So should you patent your idea? Well, yes, if it's in a patentable category like software. Yes, if it's the heart of your business. And yes, if a high valuation is important to you. How to protect your idea with a patent? You can get a patent in 4 simple steps. The first step is optional, to do a search to see if you are first, and we'll discuss how to do a search. If you're in a hurry, if you want to go public with your idea, you may want to consider filing your application first and then doing the search. It's up to you. In the second step, you prepare your drawings and text. Your drawings and text tell the story of your idea and describe it to the outside world. You then file your patent application, for example, at the U.S. Patent and Trademark Office. Finally, the examiner checks your patent application, and if it determines that your idea is worth a patent, then the patent is granted. How long does it take? Well, a search can take 1 to 2 weeks. Preparing the drawings and text can take 2 to 3 weeks. It takes a day or less to file the patent application. It can be done electronically. Unfortunately, it can take 1 to 5 years or more for the examiner to check the patent application. Now, the timeline for steps 1 to 3 depend on you. If you drag your feet, it could take a lot longer. But if you stay focused and you follow the steps in, for example, our packages, then you'll be able to quickly get through them and follow this timeline. So it doesn't have to take a long time for you to file your patent application if you stay focused. We strongly recommend starting with a U.S. provisional application as the best way to start. A U.S. provisional application has fewer rules, so it's easier to file. It's not examined, and it only lasts for 1 year. Now, why is this? Because a U.S. provisional application is a temporary application. It is meant to allow you to get your foot in the door, to give you a date that you can show the world that your idea was filed on. Within 1 year, you have to complete the process and file a regular U.S. patent application, which costs more money, is harder to do, and takes more time. So we strongly recommend starting with a U.S. provisional application so you can file quickly and be able to show the world that you had your idea in your hands as of a certain date. Now, how to do a patent search. Perhaps you want to do your patent search before you file your application. You want to see if you were the first one to think of your idea. So you can do a patent search. We recommend following these 3 easy steps. First, describe your idea with a few important words. Second, go to google.com/patents and enter those words. If you have too many results, increase the number of keywords or change them. If you have too few results, decrease the number of keywords or again change them. Now, of course, you should also do a regular search, for example, at google.com or another search engine. But google.com/patents provides a really great way to quickly check to see if anyone has thought of your idea on the patent side. One of your keywords, by the way, can also be the name of a competitor. So, for example, if Google's your competitor, you can put Google in as a keyword and you will see patents and patent applications that are owned by Google. Other important examples of keywords are those which describe your idea more precisely. So instead of software, if your idea, for example, relates to image processing, that is the analysis of images, you might want to put in image processing software. More specificity will mean that you're more likely to get results that actually relate to your invention. So is your idea patent worthy? Well, we've discussed the reasons why you'd want to file a patent application, but that does not mean that your idea is ready for one. How do you know if your idea is ready for a patent? That is it patent worthy? Well, answer these 4 simple questions. Does your idea solve an important real-life problem, and do you know what that problem is? Does your idea have a wow factor? That is it really different from what's been done before? Does your idea fall in a patentable category, such as software? And does your idea form the heart of your business? If you answered yes to these questions, then your idea may be patent worthy. So, some parting thoughts. Can you do this yourself? Yes, but you need to know the following. Idea protection can be complicated. You need a strategy. You need to be confident that you're making the right choice, so we do recommend that you reach out to experts. One way to do so, of course, is to contact us here at KISS Patent. You can go to www.kisspatent.com, and on this landing page, you will also find information related to our free patent e-course and idea audit to help you find out if your idea is patent worthy. Thanks so much for taking the time. We look forward to speaking with you further.